am stuck.
Yeah, perfect. Thank you.
Okay. It's Grant Abbott speaking. I'm here with Tony and my team from LightYear Docs and also Abbott Mourly. And what I want to do is go through today is Testamentary Trusts. So we're going to go in and I'm assuming here there's a bit of background knowledge from most of you as to know what a Testamentary Trust is. You've probably seen ones, you may have one yourself. You may have one that a legal firm's drafted up for you, which usually ends up being, you know, this thick and compendium of paper. They'll charge a couple of grand, $2 or $3 grand for it. What I wanted to do is look at the legislation, particularly the tax legislation around testamentary trusts. I also want to focus in on whether they're the best use of the trust vehicle. I'm going to look at trusts or testamentary trusts that sit outside of the will or the estate. And then I'm going to look at how to do multi-generational trusts. So rather than waiting till death for all these things to spring up, which is the very nature of a testamentary trust, is that we actually build trusts that have built-in estate planning going down the future. It's quite some time. Tony and I are building one at the moment for a client whose wife is very poorly, so I've been rushing around this. But within the trust that we're building, a leading member trust, we've got an ability once both parents pass away, that effectively whatever's left in the trust, the capital will be split proportionally between the children, the bloodline children, and they can either be extracted out of there as a capital distribution, alternatively can be left in there in effectively a sub-trust that child will control, and obviously income flowing through that will go down to the children or designated beneficiaries. So it becomes virtually a hybrid style trust on that second trust. So there's all those different competing elements, and I want to show you how to build each one of those, not necessarily that multi-generational leading member discretionary trust, because that's just in the process of being built now, and I've got a couple to do for Tim as well. So it's all very exciting as we go down the track. And no doubt you can see from all our rebranding, we've got LightYear Docs 2, which is coming up and being launched on the 1st of November. So watch out for that one. It's going to be very, very exciting. The other one is, while you're reading the disclaimer, for those of you who've done your SMSF course, if you haven't done your accreditation, I suggest you want to do that pretty quickly. In the next week or two, we'll be releasing the membership options for SMSF, foundation membership or ordinary membership. We're having a board meeting on it next week. It may well be the case that the only people who can be members of SMSF are people who have gone through an accreditation and certification process. Between now and the launch, the official launch of SMSF on the 1st of December, Tony and I and Tim will be doing a half-day catch-up for those people who are the original course members. We'll be doing a half-day catch-up on some of the more issues, the particularly around Protector. There's been a couple of cases, so I want to give you a really good high-level refresh on that one. So make sure you watch out for that one. We've got this is going out to more than 110 people. If you want to make a chat, absolutely have a chat, and Tony and Elora manning, and shouldn't say manning, personing that as we go along. If you want me to actually ask, you want to ask me a direct question, just use the Q&A there as well. These slides are going to be available later on today once the recording is complete. So you'll expect Onusa and the team will be developing that one. So you'll get the video of this. You'll also get the slides for this as well. We've also got a book, The Guide to Testamentary Trusts, which you may not have seen, and I'm going to have a look at that for you as well. You'll get that out, so we'll look at that and a couple of other things as well. So let's move on. So testamentary trusts, you've all heard about that. You know, they're the big sales point for most lawyers, and essentially it's a way of effectively being in a position of upgrading a simple will to one with a testamentary trust, so that our standard retail fees, and it depends on the complexity of it, but Abbott Mourly, if you're looking at a testamentary trust, it's between $1,800 and $2,200 compared to just a standard will, which is around about $750. I'm going to show you some really neat tricks of how to build these really quickly, and my preferred way of doing that a little bit later on. We're going to have a look at a live case study. They have one thing that we have to understand is a testamentary trust is a contingent trust. So that where a client may well have an estate plan with a testamentary trust embedded into it, it's not a trust at that stage. We should all be aware that trusts from a 101 point of view, effectively you need to have property to settle that trust. And of course, you can't have property to settle the trust until the person dies. So it's more of a preemptive template. My preference is to generally not have such a strong document embedded within the will. The only reason I say that is when you go to probate, it needs to be that document actually has to be utilised for that testamentary trust, as opposed to where you normally go to probate, you have some general terms and conditions around the testamentary trust. Then you can build that at that time, which is then going to line up with the requirements of the executor and also the will. It's a lot more flexible that way. My preference, rather than getting locked in, because we don't know if things change. So we're at the moment on that leading member discretionary trust number 1, but we might go down the track and there might be some other stuff. So when you do a testamentary trust, effectively we'll be using a leading member discretionary trust from our stable. So they're great for obviously taxation, asset protection, family law, a range of other benefits. A good friend, Linda Chen, actually suggested that I do a session, or Tony and I do a session on the impact of trusts, testamentary or otherwise, in terms of family law. And I think that's a great idea, because we have had a look at it previously in terms of Kennan and Spry, but there's been a whole lot of other cases that it's worthwhile doing a deep dive on. So we'll get out to that one probably in early December. They're not a catch-all solution for many families, and I'm going to show you a really nifty little hack for a testamentary trust for a family that you can do through our simple LYD will, which is by no means simple, but effectively can throw, I just find it's a really, really good tool for us. So it's effectively like setting up a leading member discretionary trust out of the estate for the whole family, rather than separating it, but we'll have a look at that a little bit later on. There are a lot of different testamentary trusts, and each are impacted by family provisions claims. So it's all very well to have these nice pieces of paper and stuff like that, but if there's a family provisions claim, then they can just be destroyed in seconds. So they can be pretty pointless, which is always the danger, as you know. I've got our little mates, Liz Hurley and her son, Damien. As you can see there, it's I've had a look at, or my wife's a bit obsessed with Elizabeth Hurley's son, because it actually looks more, I shouldn't say, but very non-binary, if you want to say that one. Main thing here, though, if you have a look at the heading here, this is probably the only decent article I've seen on this, but Elizabeth Hurley's son was cut from the father's family trust. And that was done by his uncle. So again, when you have a look at that trust style, there's potentially a £220 billion trust. Effectively, it's easy to get rid of beneficiaries, and they have very little recourse because the beneficiary has no right or entitlement to any asset, unless, of course, it's a unit trust. Now, if this was a different case and he was left out of a will, then that could be contested. So the difference between having a trust sitting outside the estate or doing things outside the estate versus in the estate is quite significant. And Tony will tell you, I mean, he's sending cases to me all the time as our team at Abbott Mourly. All the family provisions cases are getting I mean, there's one at least, wouldn't you say, Tony, there's probably at least one or two a week from every state, and they get into quite significant detail. And mind you, this is the ones that are actually going to court, and there's a plethora of them who are sitting outside as well.
No, exactly. We've got one basically now. It's only for $100,000 at the end of the day, and they just want to take it. They want to take it through the pipeline. So it's just crazy. It's insane.
I know. New South Wales seems to be the worst. They're making some changes in South Australia, but essentially, if you're an eligible person, you can make a claim on the estate. So I just want to go through a few core issues so you understand a few of the definitional issues that, whether I'm talking now or I'm talking down the track, these are the ones that are pretty relevant. So what is a testamentary trust? Well, testamentary trust is, by its very nature, it's a trust, and then the adjective is the testamentary. So if we have a look at that, it's a trust that is established on the death of a person or the testator. Now, it doesn't have to be in a will. Testamentary trust can be established anywhere. For example, you may not be aware, but an employer can establish a trust for a deceased employee for the benefit of their family. That's a testamentary trust, and it actually accords, I won't show the legislation on that, I'm going to show you the more relevant ones, but that also enables minors to be taxed as ordinary persons. So there's a whole list of different testamentary trusts where they fit in. Now, obviously, the ones that are sitting on the other side of the line and are through the estate or through the will or the administration of the estate, obviously, they're our traditional testamentary trust. But again, once we do that, they're subject to a family provisions claim, which is a bit dangerous. With a leading member discretionary trust, when we have it open, there's nothing. So when we're building these trusts, and Tony and I have done quite a few, we end up actually making them leading member discretionary trusts, because a testamentary trust simply has a set of terms and conditions for it as to the disposition of income, capital, etc. So in that one, we can put terms and conditions in there. For example, with beneficiaries, we have done some recently where the beneficiaries are not able to access any income unless they've submitted to a drug test, or they're not allowed to draw down capital unless it's for rehabilitation purposes. If they can show that they've been sober for like 6 to 9 months, their income, which was a weekly or a monthly income, can be increased at the discretion of the trustee of that testamentary trust. So when we start building these and start doing a deep dive, there's really no means as to what we can't do. And it's important anyway to go through this process and discuss it with the client as to what a testamentary trust is, because the terms and conditions you're going to put in here for, let's say, a testamentary trust apply equally for a super proceeds trust, insurance proceeds trust, or, for example, even that second generation leading member trust that sits, that has been continuous and ongoing for some point in time. So the discretionary trust versus the leading member discretionary trust, the main one there is, and I think this is really important, and I must admit, I think I've been a bit of a brainwave around this, is that discretionary trust, we typically have beneficiaries that we name within that discretionary trust. That includes, obviously, then their children, not necessarily bloodline, it's just any child, a grandchild, relatives, so on and so forth. Now, the issue about that, and for those of you who've been, our clients have gone through family law cases or on death, we're getting at least 3 or 4 questions a week is, well, what happens if someone's died and they're no longer the appointor, they're no longer the trustee or whatever? You really need to get involved, and you go on, you'll see on our site, there's a change in trust positions and names, and that will handle it all for you. You can extricate a trustee, you can extricate an appointor or a beneficiary, or replace them if you want. particularly if someone's got a new boyfriend or girlfriend and they want to put in as a beneficiary. But again, the weakness about that is that every time there's a change in the key appointment areas within that trust, we have to go through this process of changing the actual names, etc. If you end up going to a lawyer, it's going to cost. What I've seen recently, which that's the beauty of our change in trust names, etc. It's going to all be done in one document. I saw one that was a change of trustee, then a change of appointor, and then a change in beneficiary. So 3 legal documents to essentially do something that really can be done in one. And each document was $600 a piece. So it'll give you an idea. And again, when you're going through and using our system, if you want to know what a typical pricing is, we are building a pricing schedule for that. So if you don't want to do that, particularly changing positions, you can always send it to Abbott Mourly as well. Now, the leading member discretionary trust is just a little bit different, is that it doesn't have any specified beneficiaries. Well, it does in a way, because what it does is it doesn't give a name to the beneficiary. The beneficiary is the leading member appointor, so that it actually changes the position so that if the leading member dies, then the next leading member appointor is instantly the main beneficiary. Now, the prior leading member and their children are also included. So we've got some really good depth there, but we have these instant changes. It would only be where there's a change in trustee that's actually required. The living trust is probably, I use that term, and I'm still not sure whether I'm going to keep with that term, but the one that we're building at the moment it's a leading member discretionary trust for multi-generations. If you look at it from a perspective, particularly having a look at the Commissioner's cases, or Commissioner's Guideline 2012/21 TD, commercial nominees, and Clark's case, it's quite apparent that there's no CGT event in the case where the underlying trust continues on. And so if we vary the trust, again, there's no resettlement, or that's not a creation of a new trust. The only time we end up creating a new trust is if we potentially pull an asset out of a trust and send it over to another trust. Then that new trust would be a brand new trust, obviously, but the old trust would still retain, but there would be CGT for the old trust. So one of the benefits that we miss out on in estate planning, and really the original trust was built to get around death duties in King Henry's time. Many, many years ago, it became very popular that there were not, obviously there'd be death taxes on the death of a knight or a lord or whatever on their estate. So they started to build trusts, and then that suddenly took off. Many of you, particularly the youngsters there, you're probably not aware we had death duties. Each state levied death duties up until 1972, when I think Queensland knocked it out, which then had a knock-on effect across all of Australia. And you may not be aware, I did a bit of a snip the other day, or a bit of a capture of an article that some top tax people around Australia, tax economists, are highly recommending a death tax. So moving more towards these living trusts, or these multi-generational trusts is worthwhile. Now, that 80-year rule against perpetuities was obviously brought in to make sure that there was some money that it ended up in government or the state, and you couldn't go beyond 80 years. In the old days, it was, I think, King George the 6th living heirs, or the 8th living heirs, so on and so forth. So but the rule against perpetuities in most states, with the exception of South Australia, is that you have a maximum of 80 years. But now, if we choose the jurisdiction of South Australia, it doesn't matter where the trustees or the individuals are, the beneficiaries, or the actual assets are, that in essence there is the rule against perpetuities doesn't apply. So it's an indefinitely continuing trust, much the same as the corporate trustee is indefinitely continuing until it's wound up or vested, which means we now start to move down, passing wherewithal down through future generations. And again, if we encapsulate everything within that one trust, then essentially there should be no, well, there's no capital gains tax according to the Commissioner, unless we pull an asset out and set it up in a new trust, and also no duties as well. So we've just got to be, we're doing a bit of research on that around the duties if we have, you know, second or third generation in there, but it's certainly a great way of passing wealth down from generation to generation without having to go through the procedures within an estate, which is probate, family provisions challenge, so on and so forth. Then we have to do an investigation of the CGT and stamp duty consequences there. So it's quite a lot, whereas we've got a nice little confined entity that we can pass on between generations. Seems to me to be one of the best ones. And of course, then we've got our basic estate testamentary trust, which is okay. The Testamentary Trust, as I said there, traditionally one, if I'm looking at superannuation, quite often you'll see a clause in an estate that the superannuation is to be transferred from an industry, retail, or an SMSF to be transferred over to the estate, and then we call a super proceeds trust is established for that. So it just means that that testamentary trust only holds the original super, doesn't get blended with any other assets of there. So that's a super proceeds trust. But again, both the testamentary and the estate-based testamentary and super proceeds both cross that line, are open to family provisions challenges. Whereas an SMSF proceeds trust, or we can have a super proceeds trust. I'm dealing at the moment with an advisor and looking at monies coming out of a managed portfolio where the client's died and being paid directly down to the spouse, who then settles that or gifts that into a leading member discretionary trust. But that will obviously fit the needs and be akin to a testamentary trust in terms of tax purposes. So that's a different way, but the main one with that, excluding of course New South Wales, which has, it probably may well be tested because of their a couple of their notional state consequence, but every other state essentially that would sit outside the estate because it's being paid directly from the super to the individual, and then on into a trust, which is what we basically want. Just got to be very careful that if the individual is bankrupt or whatever, we've got to be careful about that one. Insurance as well. If there's an insurance policy on the individual, likewise, if, for example, Tony's got an insurance policy down to his spouse, Agatha, she receives the proceeds, she can put in that money into a trust, and that would be classified under the generous income tax rules. And likewise, in fact, she's got 3 years to go and put that property in there if she wants for a testamentary trust. But because Tony's all his children are over 18, it's probably not really an issue. Split trust versus clone trust. Obviously, with cloning of trusts, the Commissioner has given unfavourable guidelines in terms of capital gains tax, but split trusts, which is that second generational, third generational, where we start off with the trust, but then it starts to break down into further generations, which we're working on, that you'll start to see that, that there'll be a capital, I think what I did, split capital beneficiary or capital split beneficiary, so that we can start to build it in there for future generations as well. Family allowances are important as well for SMSF. Don't ever forget those ones as well. So let's go and have a look at the lovely legislation. Sorry, it's not the best looking, but I just wanted to raise a couple of issues here for you, so you know. So we should be aware that minors, with the exception of employment income and business income, any child under the 18, if there's a distribution for a trust, it's obviously taxed at the penalty rates for minors. There is, though, accepted trust income, and you can see here, one, we're a beneficiary of a trust estate. Let me just get my little annotation, my wee bouncing ball, so you can have a look at this. Okay, just get out of the way. So we're a beneficiary of trust estate as a prescribed person, that's a child under 18, in relation to a year of income. This division applies to so much of the share of the beneficiary of the net income of the trust estate of the year of income as, in the opinion of the Commissioner, is attributable to assessable income of the trust estate that is not in relation to that beneficiary, accepted trust income. Now, accepted trust income means it's not subject to the vagaries or those income tax penalties. So they're just minors, are just taxed as ordinary beneficiaries, which would be fantastic. Wouldn't it be great to have all of our trusts like that? But unfortunately, so subject to section, amount including the assessable income of a trust estate is accepted trust income in relation to beneficiary of the trust estate to the extent to which the amount is assessable income of a kind covered by subsection 2AA of the estate resulted from a will, codicil, or an order of a court that varied or modified the provisions of a will or quarter, or an intestacy or order of a court that varied or modified the application in relation to the estate of a deceased person, or the provisions of law relating to the distribution of the estates of persons who die intestate. So in short, what that is, that's our classic testamentary trust. So it's a trust that we see in our estate. Now, it could be that within our will, we've got a position there that we've already got a preordained set of testamentary trust deeds that now need to be put in force into action. Alternatively, it may be open and then the executor decides to build a testamentary trust. In that instance, if they've got the power to do it under the will, absolutely. And the same thing in intestacy, you might build a testamentary trust from there. 2AA, we won't go into it, but essentially before what happened is you'd build a testamentary trust, you'd have the proceeds from the estate, but then people then start shipping in other assets, other property in order to increase the underlying capital and hence the income of the testamentary trust, which could then be siphoned out to children. So effectively, you're just pumping up the gas, so to speak. So 2AA says the only income that can be passed out that's accepted trust income is obviously that's relevant to assets from the estate. So subsection 2 is good there. 5, directly as a result of the death of a person and out of a provident benefit or superannuation retirement fund. So when you have a look at here, one talks about a trust that comes out of a will. Another one is a trust that's built as a result of the person and out of a provident superannuation or retirement fund. So that means that when money's come from these funds, and industry, retail, or SMSF, we can build our own trust. And then if there's minors there, then it's accepted trust income. But notice here, the catalytic event is actually the superannuation or retirement fund, not the will itself. So this sits out, and this is it's like a huge difference. Family provisions claim, non-family provisions claim, except potentially the notional estate in New South Wales. As a result of as the result of a family breakdown, that's also useful for child support. So you can actually create child support trusts, which we put property inside a child support trust, and then obviously pay education school fees out of that, and then the children are taxed as ordinary assessable taxpayers. So that's anyone who's ever going through child support, this is absolute cracker to have from there as well. And I'll put in D, I'm not going to have a look at that, have a look at it in your own time, but that talks about going back up to 3 years and making changes there. So that's essentially our laws. I haven't put in the insurance proceeds one or the employment one, but that's also there as well. So we've got a range of testamentary trusts, but they do come from different places. So let's get some rubber on the road here, and I'm going to take you through a few things. So we've got John, and this isn't overly sophisticated. We see this probably a lot of time that people come to us, and I'm sure for those of you going down the SMSF route, you'll find that you're coming across more and more this big issue about protecting family wealth. And just to give you an idea for those of you who saw my blog last week, if you're an employer or anyone, you must use the protector. You cannot have assets in your own name at this present point in time with potential COVID litigation hanging over your head. If an employee or a staff member, obviously a contractor, whether it's a subby or alternatively a customer gets COVID and it can be pointed that they got it or traced back to your premises, then there's potential litigation there. Likewise, is the reverse is that you can get COVID from other people who have got COVID, and that's the vaccines, as you see. Have a look at Greg Hunt the other day. He said the maximum lifespan is 6 months. You're going to have to need boosters. Over in Israel, I think it's like 3 or 4 months. They've tested it. They're up to their 4th booster, or their 4th shot at the moment. So the question there is that obviously the COVID is transmissible amongst people, whether they're vaccinated or not. So that there's a huge amount of litigation out there. One of the ones that Tony showed me is a bill which is in the Legislative Council in New South Wales. Hasn't gone through yet, but who knows what will happen. But it gives an employee a lifetime right to sue their employer if there was a vaccine mandate and they became injured as a result. And even though it's now, it might be 10 or 20 years down the track. So if there's ever a time for asset and family wealth protection, this is it. So let's go through and have a look at how this plays out in this instance. So we've got John, who's 63, married to Sally, who's 60. They've been happily married for 40 years, have 2 children, Ben, aged 35, and Simon, who is aged 32. From that, we've got Ben works in John's business, which produces safety gloves and operates through a company, SF Proprietary Limited, with John as the sole shareholder and director. So the first thing you're going to do there is obviously put in a successor director solution, or given the fact that Ben works in John's business, I would make sure that effectively Ben is probably an existing director there. Change it to a leading member company and have Ben there as the leading member shareholder. Now we go down to Simon, who's a problem child, has an alcohol and drug problem. He's caused his parents grief, stolen money from them. At this time, they want to limit any money going to him if something happens to them. They don't want to leave him dry, but give Ben control, as he loves his brother, but is not stupid. Okay, so let's go down and have a look at the next slide. John has a family home worth $1.2 million and no mortgage, so he's exposed there. An investment property worth $600,000 with a $250,000 mortgage and a SMSF. The SMSF has 2 members, John, who's the sole director of the trustee company, as he holds Sally's special purpose EPOA. His account balance is $1 million, which consists of a $950,000 factory, which is rendered to his company and some cash. Sally has an account-based pension, which was commenced in 2019 when she retired from work. Her current balance is $750,000. There is no reversion. We've got 2 grandchildren, from Ben, which is Alice and Sophia. So when we have a look down there, we've got a lot of stuff going on. I'm just going to go through and we'll go through the facts again, because I'm going to go into a build now. So we've got John, who's 63. So obviously if he gives up one form of gain from employment, he can commence a pension. We've got Sally, who's retired and has commenced a pension. Happily married for 40 years, so that's good. So we don't really have to worry necessarily about family law issues or blended families like we did a couple of weeks ago. 2 children, Ben, who's the good one. So he's working the business, and Simon, who's the veritable black sheep. Now, just on that one, I'm going to go through and I am going to build the trusts, etc., just to show you, because I think it's good. But where you face like this, you're virtually stuffed, because it doesn't matter what you do. If you try to limit what's going to happen with Simon, if he gets a good no-win, no-fee lawyer, he's going to get quite a sizable part of the estate. And what we're looking at is what happens when John and Sally passes away. Because in essence there is that obviously Simon had been looking after him over a period of time, and subjectively the Supreme Court, if you have a look at all the decisions, will go through and say, well, hold on, Ben's in the business, he's got the business, he's looking after that. And that's one of the areas that, who's going to end up with Ben's business, is that in that instance that Simon will be looked after. And again, it's family provisions claim. So there has to be a provision from the estate to look after Simon. You can't do that just at the behest or the discretion of Ben. It's lovely to think you can do that, but essentially it will be up to the court to essentially do that. So we've got superannuation, and remember we can build our own superannuation proceeds trust if we want. And then we've got 1.2, and we've got around about $350,000 in their investment property there as well. So let's go out and bounce out of there. And I did this morning, what I did is I built here, I started off doing, I can tell you, it's a drama to try and build all these documents together. My go-to is always the Moat Castle. I'm going to show you why shortly. So in our system, I've got the Moat Castle, and you can see up here in the URL, this is the ID reference number. So when we get that ID reference number at Abbott Mourly, we can then go into the document from a Word perspective and make changes. So what I've done is we've got the back end, and although this back end is only going to be around, it'll be around for a few more months, but obviously will be supplanted by the new LightYear Docs 2, which is coming out. So you can see these are all the documents that are going through. We've got that. Well done for someone there. He's doing the Moat Castle, and here's Grant's preempted Moat Castle that we've got there. So I'm going to relaunch that, and then we'll have a look through there on what we're doing. So I'm going to build a whole lot of stuff, and then we can basically thrash it out and turf out what we don't want. So I've got the common parties. So I've got John Smith there, Sally Smith, Ben, his two kids, Alice and Sophia, and I've got Simon Smith, the wee black sheep. I'm going to go to the documents. I could do the protector there. So my feeling is that I'd probably, because he's got both the investment property and also the family home in his own name, I probably would go down and doing the protector for that. But I'm going to leave it blank at this stage because I just want to show you the difference between the three. So my go-to in this would be the protector to keep it away from the estate and potentially the no-win, no-fee lawyer. And look, honestly, if you had a look at that, I'm not sure what his business is worth, but you've also got those shares which are sitting in the estate. So the shares of the business, the family home, and also the investment property could be tied up for quite a long time by a good estate planning litigator. And during power of attorney, I'm not going to look at that. But as I said this morning, I preempted it, is you've got to make sure that you have all of your family's EPOA. It's absolutely crucial. Don't expect to get a MyGov anything because everything's digital these days. And you can't have access unless you can show an EPOA. And even that takes a long time. You really just need to make sure you've got that backup, because if you don't, you're virtually being ostracized. It's almost like being unvaccinated. So what we can do here is we can do, if we wanted a leading member discretionary trust, and so that's if we wanted to keep it outside. I'll come back and do the protect a little bit later on. What I want to do though now is I'm going to do an SMSF will for him. So that's okay. I'll have a look at what we're going to do with the SMSF. Then I'm going to do a simple last will and testament. And then I'm going to change that to the will and testamentary trust. And remember, as part of because you're building this out of data collection, you'll always go yes, and then put your details there. So Jim Jones, first counts. So you'll go through that process. So let's go through and have a look at the superannuation fund. So I've got now I would have put in the corporate trustee already into the common parties, but I'm just showing you what to do now because I was assuming I haven't done it. So the trustee, we've just got a company here. I'm going to call it Smith. Now, if I was going to use it again, I would have again put it up there, particularly if you're looking at family allowances. My recommendation would be in this instance to ensure that the two children, Alice and Sophia, are both being looked after, or family allowance for their education, etc., being provided by John. In that instance, that would make both of them effectively John Smith. So that would make them both effectively financial dependents for John in that instance. Now, remember, I've only got one director here, although Sally is also a member, because John has Sally's enduring power of attorney. She doesn't want to get involved, so we're essentially off and running that one. Okay, so binding death benefit nominations. So I need to put in the member's name, so that's easy. I've just got John Smith. Now, this is where there's a difference between here and a BDBN. So in a BDBN, you're generally just going to have a payment of death benefits. So that's okay, but it's pretty boring, really. So here, what we want to do is, this is where it's more akin to a real will. For those of you who've seen you've all seen real wills, you revoke earlier nominations. Do you want a reversionary pension to take precedence? I would say always is the case. Here is a replacement trustee. So if you've got that existing corporate trustee, do you want the executor of the estate to come in and become a replacement trustee or replacement director? I would say yes, because if you're using our constitution, they're the only people who can then distribute or disperse death benefits. So the other directors have no vote or count in terms of distribution of death benefits. Do you want to distribute death benefits? Yes. Does the member want a professional look after the estate? Absolutely, that's where you come in. And then if it's a non-complying fund, do you want a catch-all clause? Absolutely. So we just jump into the death benefits estate. Does the member want to nominate beneficiaries or their estate? So if I go to the estate, then there's a whole things about, you can pay it through the bloodline, whatever, which is okay. But again, that's going through the super proceeds trust. It's going into the estate and it's subject to family provision. So there's no way in the world I would do that for this instance. So who's going to get the money? So it's going to go to Sally. She's going to get 100% of my super benefits. So that's okay. And now I want to just show you for this one here. So she's to get the whole lot. Now the question is, if Sally's not alive, who's to get the money? So I would pay it, you could put it to any surviving beneficiary in equal proportions. So that may well be both children, so Simon and also Ben in this instance. But what I'm going to do is I'm going to pay it to a secondary beneficiary. So in that instance, then the secondary beneficiary, what I'm going to do is, yes, who is it? And I'm just going to limit that to Ben Smith, or alternatively, and I can go 100% of my super assets, my super estate. Now I want to make sure also that Ben is financial dependent, again, using that family allowance within reason. Otherwise, what I can do is I can switch that to Alice if I wanted to, but I'm going to stick with Ben. Now, if Ben's not around, I would tick this one. So if Ben's not around, then it goes to the deceased estate for the sole benefit of the deceased bloodline, unless an SMSF Death Benefits Trust can be established under the superannuation laws. So I would go that, because then you can do a Death Benefits Trust, which is that Testamentary Trust that's created, and that will be for the benefit of Ben. Ben's not around, obviously, his children as well. But there's a couple of other ones here as well, so have a look at that. Tertiary beneficiary, we might have, well, if none of the kids are around, we just make it Simon. So 100% of my super. Now remember, this only happens if all the others aren't around. Superannuation interest. And then I would do it there, other. I would put there to be paid into a trust with a qualified professional as trustee and no payment. Well, I'll just leave it that one. That seems to be good for me. Nominate professional. You just put your details in there. John Jones. Or First Accountants, I think it was. First Accountants. Oh, sorry, no. You need to put in there ordinary, so what your payments are, because this is a contract, ordinary partner fees. Then firm name, First Accountants. And then the importance of doing this is that this is a contract that is binding on the trustee of the self-managed super fund. So if they decide to get rid of you, then they're still required to pay fees for you. So that's pretty important. Where is the meeting? We've got John, and then we just pick his home address is where the meeting is. So that is your SMSF will there. And as you can see, the first it goes to Sally. She's got an option of taking it as a pension, a lump sum, paying it into an existing trust, or setting up a separate SMSF death benefits trust, which is that superannuation testamentary trust that flows out of the super fund itself. She's not allowed, then Ben can do exactly the same. He won't be able to take a pension, obviously, because he's over age 25. But it'd be great if we want to go down the track, we could get both Sophia and Alice to receive that pension, which effectively will go for their life if they want. They're not limited by age 25 because they're not a child. So what I'm going to do here is I'm just going to build a quick will with Testamentary Trust. I love this little one that I've done. We can make another will for the spouse if we want. So that's, I can make one for Sally, but I'm not going to do that one at this stage. The testator, it's John Smith. Do you want to appoint a professional advisor? Again, this is pretty important for you. So we've got John Jones from First Accountants. Okay, so then we go down there. If you want to see, more than happy, if you like, to provide these documents to you as a sample after this session. If you want, just let our team know. So the executor, in this instance, this is for John, Sally's not interested in being a director of the SMSF, so she shouldn't be the executor. So I'm going to make that Ben, that's the son. So we've got that. Successor executor, in case Ben, I'm not going to make it Simon, so I'd probably make it maybe Sally, or alternatively, might make a friend. So, John, friend, or alternatively, if there's no one left, and my feeling about this is that I prefer not to do it. I prefer you just to act, but sometimes there's just no way out of it. Although it's not a bad idea sometimes to get lawyers involved because they can take the heat. Second successive, we'll go no there. Okay, specific gifts. Would you like to have a specific bequest as part of this will? I'm going to go no in this instance. Now, this is what I like for this one. Do you want all of the proceeds from the estate after costs, taxes, blah, 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 to go into a single testamentary trust? I would go yes. Is the spouse to be included as a beneficiary? I would say yes, so that's Sally. Are there any related entities? No. And are there any other further terms and conditions? The trustee and appointer of the trust is to be Ben Smith, and in the event alive, it is to be Sally Smith. So when we have a look at it, who is it? Simon, Ben, and his bloodline children, and also Sally to be beneficiaries. as all relatives and sorry about that, relatives, children of Smith. The testator. Now, for Simon, his income, Simon is not to access any capital unless it is for rehabilitation or that he has gone 5 years sober. Anyway, we'll just go down that track. When we have a look at that, so that's a sort of that's a good strong testamentary trust that comes out. Now, if by doing that, if I go out and go no, then you can see what happens there is then I have to go through principal beneficiary and all that. But this is just a good catch-all testamentary trust that flows out that essentially Sally and the whole family will do. So this is creation of a leading member trust, which is good. But remember, of course, we'll go to child guardianship. At the end of the day, it's going to be a position that is still subject to a family provisions challenge. Now, of course, in this instance, it's not too bad because Simon is going to be looked after in one way, shape or form. So that's why I like it. I think it's pretty good. Would you like to include the funeral? Yep. It's so cremated and tossed Sydney Harbour Bridge. Okay, so when I have a look at that, essentially there I've got a couple of really good strong documents. So I've got an SMSF will I'm going to show you that has the SMSF Death Benefits Trust, and then I've got a separate will and testamentary trust there as well. But at the end of the day, I'd keep the SMSF. So let me just download this document here. So I wanted to show you what we were doing so you have a really good understanding. So again, the Moat and Castle, by having that common parties, enables me, so I can always go back and relaunch that Moat and Castle. I can add EPOAs in there, I can add spousal wills, but this just shows you how we can get to a situation. So here's the letter to John Smith from Abbott Mourly. I'm talking about being paid from, being made from a data capture that you guys have created. So that's a good one. Second one is a general advice letter from Tony on about how to execute the will, etc. And then we go down into the SMSF will. Look, it's nice that Dan said, you know, good old Dan for that sort of stuff, but, you know, SMSF will ties directly into our deed. So it's very strong. And as you can see, does a lot more than your typical binding death benefit nomination. So this is a product disclosure statement that the trustee has to give to the individual. Unfortunately, trustees are not bound by the Corporations Act, with the exception of the PDS requirements. So I've got an application by John Smith. We revoke the earlier one. You can see there one. Reversionary pensions take precedence. So this means that, as I said, John's age 60. If he gave up work at this stage for anything, then effectively he'd be able to access all his super and be able to take a pension, which seems to make sense. So then that means this SMSF will becomes redundant because he hasn't got any accumulation unless he continues to put accumulation monies in there. We've got our replacement, our executor, who's going to be our replacement trustee and member. So this would put in play Ben, who's not a member of the SMSF, because he's the executor of the estate. He would then come in and become the replacement trustee or the replacement director of the corporate trustee, and then will be the only one who has the authority to then delegate and officiate on this SMSF will. So you've got the death benefits of the fund. Whenever you see this here, it essentially means that I've left a block out. So I'd have to go back and relaunch, but because I didn't put down what relationship Sally was to, obviously, John in this instance. But you can see here, this is what I really like out of the system is the death benefit payable, 100% of my super benefits. The benefit may be paid as an income stream if allowed under the super laws, are transferred directly to the designated beneficiary of any trust, company, person, or other entity the beneficiary directs, including a transfer of the deceased member's estate for the asset to be held specifically for the beneficiary in a trust for that purpose. So that's okay, but at the direction of the beneficiary or any leading member, the trustee may create an SMSF Death Benefits Trust to hold the designated bequest. And then it goes through the appointorship. So I like that because it's giving you the ultimate in flexibility. If the beneficiary is not alive, it goes to the secondary beneficiary. And then we've got Ben Smith. I didn't put down there was the son. Same sort of thing. If he's not around, then this is what's going to happen for that one. And then we've got Simon as well, who's got that flexibility. If Simon's not alive, then it's just to go be paid. So it's to be paid into a trust with a qualified professional. So that was his one there. The nomination of the professional review the estate. You've got John Jones there, and then we've got the signing off of all the relevant people. And then there's the resolution by the trustee. From there, we go into the last will and testament. So again, we've got, remember, this is the testamentary trust solution. Ben's the executor, Ben's not around. Then John Jones is who's the accountant, is a successor executor. Provision of advice is by John Jones. Obviously, there's the initial administration of the estate. And then we jump straight into a bloodline testamentary trust. So the remaining estate, including any super benefits after any specific gift of my super benefits, is to be automatically transferred into a testamentary trust to be created on my death with the following terms and conditions. Beneficiary will include the spouse, bloodline, blah, blah, blah. Just the important of a trust is to be Ben Smith in the event that Ben is not alive. So that's all the stuff that we did before. And then we've got funeral, other wishes, general powers of executor. And then we've got specific powers. And then we go into trust powers as well, testamentary trust powers, etc. So that's a nice little different way of doing things. Alternatively, given the state of play that we're in, if I go back to launching this as well, so I'll relaunch. If you're looking at doing life interest and look something a bit more sophisticated and building stuff for both parties, what I can do is I could go down here and I'll show you when I go start off the documents. Rather than doing just the will with one testamentary trust, I can actually do wills and testamentary trusts here. So I can go through here, start the same thing, last will and testament there. General is the same. Is there a life interest? I can go yes, and that could be, for example, for Sally's property. So testate is the same, executor is the same. So all I'm doing is just upgrading on the fly. With what we've got, specific gifts, no, exclusion of persons. Do you want to exclude anyone from the estate? It's nice to have that in there, but honestly, it really, if they need to be looked after under family provisions claim, they will. So principal beneficiary. So here I'm going to go through Ben Smith. Actually, I'll go through Sally Smith here. And remember, this is where I didn't do this, so spouse. And when we have a look here, we might just go, let's say 50% of my estate, because remember, she's getting the property. Do you want this to go? Any specific gift or any specified percentage can go into a testamentary trust. So we then go in there. Then we've got some series of, because we're building this testamentary trust on the fly compared to the other one, which is more a short form. So is the beneficiary share of the estate to be automatically transferred? For Sally, I would go no. It's at her option. Is her spouse to be included with the main beneficiary? No. So that's because obviously John doesn't want Sally remarrying or getting involved with someone in the moon to become a beneficiary. Do you want the secondary beneficiary bloodline or lineage? Yes, so that includes Ben, Simon, and Ben's children. Are there any other related entities? No. Is the main beneficiary the appointor? Yes. Then I can put in other terms and conditions there. If the principal beneficiary is not alive, their share of the estate is to be transferred to, basically we could do again the secondary beneficiary there. Now I'd have to do, because I only did, in fact, what I'll do is I'll make this 100% of my estate. Okay, then I can go down to secondary beneficiary. Is there a secondary beneficiary? Yes. I can go down the track and go Ben, son, 50% of my estate. Is this to go in a testamentary trust? Yes. Is it automatically? No. If it's not automatic, it means they don't have to put it in there. Is the spouse? No. Yes. No. Yes. So that's okay. Now I have to add another one. Now, if they're not around, then it's going to be held for their bloodline children on trust. So it just means that Sophia and Alice would get a bloodline trust there. Now I've got another one here. This is where it gets a little bit more fun. So we've got Simon here, son, 50% of my estate. Do you want this to go into testamentary trust? Yes. Does it be automatically? Yes. Is the spouse? No. Yes. Secondary bloodline? No. Are they appointor? No. So Ben is to be the appointor and trustee for the trust. If Ben is not around, then the executor is to be appointor and trustee, but must always hold the estate over the trust. Capital bloodline is, and we can put in there the sober and all those other terms and conditions there. Tertiary beneficiary, is there a tertiary beneficiary? We could just say, well, we'll just make that Alice, daughter, 2 Ds there, and then 50% of the estate. And that's to go into a testamentary trust. Yes, no, yes, yes. You can still do her as a beneficiary as the appointor, even though she's young, but I'm going to go, no, that's a bit silly because Ben will look after that one. And if she's not around, then to be provided to any surviving tertiary beneficiary, and that obviously is going to be Sophia. And so that's daughter. 50%. As you can see, this one's a little bit more, I'm almost finished, so sorry about that. Yes, yes, no, yes. So by excluding the spouse, I'm making sure it's really bloodline. Is no, and then we go down the track there. Digital assets, I'm just going to go no. Child guardianship is a no. So that was already in there anyway, pet guardianship. Life tenant of the property is, let's say it's 5 Smith Street, Sydney, New South Wales, 2000. Reasonable expenses. Years, so we can do that. Funeral wishes are the same, and then we go down the track. And suddenly what I've done is I've upgraded my will to one that's a little bit more sophisticated than testamentary trusts. I won't bore you going through that stuff, but suffice to say, probably given Simon's particular proclivities, we could either go down this testamentary trust, know that there may well be a family provisions challenge, or I would probably go back and do that protector and that living member trust, which we haven't got time to do today. Let's just go through a few of the questions before we wrap up. Sorry, I've gone over time. So Daisy Daniel, I've come across the terms death benefit guardian. Is this the SMSF will, or is this the same as an EPOA? So no, a death benefit guardian, generally you'll find that may well be in an SMSF will. You also find them, they may well be in testamentary trusts. They're pretty old school things. essentially what they're there is to, particularly for minors, to look after, or in Simon's instance, to look after and make decisions on them. In our living trust, we're coming up with the concept of an advisory board, which may consist of one or more of a professional, being an accountant, or a financial planner or a lawyer. So we're going to be going down and looking at that and starting to embed that in our trust documents, which will then flow into testamentary trusts and SMSF wills as well. So that's a good question on that one, Daisy. Paul, when completing the setup of a leading member trustee company in LYD, do we need to list the future directors under company associates? No, you don't. The main thing is just to focus in on that leading member appointor. If the trustee company is set up for a protector, should the first LM director, secretary, shareholder be dad if he's still the director of a trading entity, or should mum? Now, look, I'm happy with dad, because remember, if there's the smallest sniff, we did this the other day, there's a smallest sniff in the wind of something going on, then dad just gets out of there and transfers it over to mum. But either way is perfect. The only thing I would say there, Paul, is if it all goes to mum and then there's a divorce, then she's really got the keys to the castle, so to speak. So probably if you go dad, then mum, is not a bad idea. 3, when setting up a leading member discretionary trust, how do we add more than 4 successive leading member appointors? You can probably I use Nitro PDF Pro. I might maybe, Laura, if you could take that on and maybe expand the number of successive leading member appointors under the new system, take it up to 6. 6 should be okay, I'm pretty sure there, Paul. When setting up the leading member discretionary trust, can you explain the outcomes of the yes/no question? Does the leading member want their spouse to be a beneficiary? Okay, so in the leading member, it's their current spouse, because obviously it's bloodline style, and it would mean there that in that instance, if you have a spouse, you need to include them, otherwise they'll be excluded as beneficiaries there. Which you can also see when we went through the testamentary trust and we're building them there. Do you want their spouse, so that's the main beneficiaries, their spouse to be included? But again, if you exclude them, it means they're not part of the beneficiary because they're not bloodline. So it's really more of a bloodline question. Ken, do you have to specify how the super will is linked back to the SMSF? That is via deed amendment. It's a standalone document. So it does reference in the trustee minutes that which is accepting that SMSF will. So the process which follows the deed, Ken, is that there's an application and there's acceptance. So once the trustee accepts it, that then binds it into the governing rules and becomes part of the governing rules of the fund. And although it's not really a standalone document, it's a document that then becomes part of the governing rules of the fund, is enforced under the SIS Act and also the Commonwealth Crimes Act as well. I noticed that Ben's spouse has been left out totally. Absolutely. So you can put Ben's spouse in if you want. There's no way, the way I discuss it with clients, I'll say, look, what we're doing is we're building a perfect Smith family cake. So what we know is we know all the parties are going to end up eating at the cake, who's going to be left out, etc. But how it works out, whether you want a spouse in or a spouse out, second generation, you want them in or out, we need to know that up front, because the more we can bake that cake perfectly now, the better off it is. So if you want Winnie to bring Ben's spouse in, absolutely. But then again, that starts to water down the bloodline aspects as well. But notice, though, even with that one, by bringing the spouse in, if she has children from another person, or he or she has children from another person, they're not excluded as beneficiaries. So can the trustee, Daisy, the trustee TT dissolve and wind up? Absolutely. So you can actually set up the TT if you want, then wind it up within 3 or 4 weeks if it's not for you, depending on what the T's and C's are around that. And again, if the Testamentary Trust is established in South Australia, there is no 80-year rule on that one. So look, there's a few, that's my session. sorry it went over, but it's pretty easy to get tied up literally in all of this. We've looked at quite a lot. As I said, from my perspective, there's all these questions that we had to look at. You know, from my perspective, I would probably, given Simon's issue, I would use the protector and also over the shares. I may even use the business protector to take core assets out of John's existing business and then lease them back to the company, so that we try and limit the exposure outside to any family provisions claim. Looks as though family law is not going to be an issue, but you know, if you're having a look at someone anything to do with plastics or whatever, there's always a chance that there's going to be litigation against them. And going back to what I said around COVID, any employer who's got assets in their own name, whether it's companies or whatever, you really need to start restructuring these as well. Tony's already telling me about a number of cases that are coming up, which is interesting. The split one there, I've got a nice little one, but if we are going to go to the protector, we want to start looking at what happens as to when John and Sally both pass away, and that's when it becomes split. We could have instance, for example, that Ben and his family are looked after with one lot of splitting of assets and then, or splitting of monies. And likewise, exactly the same with obviously Simon. But in Simon's instance, that might be an instance where, for example, that we do have, I think Daisy asked a question, having a guardian over Simon, or as we'll be putting in the in there an advisory board that is helping Ben look after Simon if need be. But if there's no Ben around, that we can have an advisory board that is there to make decisions for Simon generally, subject to, of course, you know, that he's got rehab, he's sober, so on and so forth. So that's our next level of where we're going. But at the moment, you've got a really good, you know, I'm using that little basic SMSF will, sorry, not the SMSF will, the will with test, you know, the basic will that's got the testamentary trust option. I like that because it leaves, you know, if there's husband or wife, it leaves the wife has the option of building that testamentary trust for all the family. So it's creating that leading member discretionary trust. So I really like that methodology. If you want to get a bit more detailed into specific gifts, life interests, and building testamentary trust for different elements of the family, and something that's a lot more substance, then obviously the secondary, the LYD will with testamentary trust is there. You know, from my perspective, to go in and have a look at where we are here, what I'd end up doing is I'd start off with that base. But this is the beauty about the moat and the castle. You saw how quickly I moved from a simple will that had an attached testamentary trust to going back and doing a more detailed testamentary trust as well. So the other ones are, is obviously I'm going to go in, I would go in and I'd probably do the protector in there. If I did the protector, you're going to find there that I would also build the family protection trust in there as well. So we've got a lot there. If we've got an existing SMSF, I would be upgrading the Constitution and also the SMSF. Family allowance over Sophia and Alice, and hopefully Ben. Simon's probably already in there as well, doing a reverse dependent declaration. And with the reversion, Sally, I'd go in and do an account-based pension with a reversion. So I'd add probably either John or alternatively Ben, and if it's Ben, obviously has to take a commutation, or then following on for Sophia or Alice. So you can start to see there we've started off in the basics, but the moat castle is the place to go, because at any point in time I can turn these things off, and then I can just do, for example, I might not want to do that, but I just want to focus in on this one for the client. You know, go in, do your last will and testament. You saw all those ones there, print that out, and then sell them, then send them the will with testamentary trust, so you can then make a comparative of the two documents there. And then it shows you've given them two completely different methodologies. But anyway, it's I'm 20 minutes over, so I really apologise for that. But it's not a, you know, this is an advanced session, which is really important for us to get into. But look, thanks for turning up, Tony, and helping along the way. So always your good comments are good. So how did you find that session?
Oh, excellent. Lovely.
Yeah, there's
always.
I know there's a lot in there, so you're definitely going to need to watch this once or twice. And look, appreciate everyone for coming along and asking all those great questions. So it makes a big difference. But anyways, Grant, Tony and the team from LightYear Docs signing off, and we'll see you in a couple of weeks. And just remember, 1st of November is LightYear Docs 2 launch. You're going to be absolutely blown away.